Merci d'être venu. Bonjour à tous. Je suis Steven Sawyer, directeur de publication de la revue Tocqueville, ainsi que directeur du Center for Critical Democracy Studies dans le bâtiment en face, que certains parmi vous qui ont une longue histoire avec la revue, vous connaissez ce bâtiment comme le lieu de l'OFCE où était Laurence Dubois-Freinet. Et donc, du coup, la revue Tocqueville, avant qu'on puisse l'acquérir ici à l'Université américaine de Paris. C'est un vrai plaisir de vous accueillir ici aujourd'hui à notre colloque Tocqueville. Nous avons décidé cette année de traiter la question de l'autocratie versus démocratie. Je vous remercie de votre participation et vous souhaite le bienvenu pour nos journées de discussion. Alors, dans l'esprit de notre revue, notre colloque sera bilingue. Je vais donc tourner maintenant vers l'anglais, mais vous pouvez parler la langue que vous préférez, entre le français et l'anglais. Vous choisissez ce que vous préférez. Là, je vais tourner vers l'anglais. Donc, so before I say any further words of introduction, I would like to say thank you to all the participants for joining us. I'd like to say thank you to the audience, and we have some guests. We're just very pleased at the group that we have with us here today. A special thanks to the editorial board of the Tocqueville Review, and in particular Françoise Méloniaux, Catherine Audard, Art Goldhammer, Laurence Dubois-Freinet. And I'd like to thank Zach and Kira, who Kira is somewhere, but Zach, thank you for your extraordinary work in making this happen. Unfortunately, the president of AUP, Sonia Stevens, could not be with us today. She is at the graduation of her son from Williams College in the United States, which is quite a good excuse. But she did want me to express her, to welcome you to AUP and express her wishes for a fine and stimulating conference. So just a few quick administrative details. As you saw, coffee and refreshments will be out in the hallway. The restrooms are just to your right after the hallway. When we do the discussion, we actually, instead of running around with a microphone, we'd like to ask you to come and ask your question up here at the top. And when you are speaking, please try to speak into the microphone as much as possible. We are recording the event. So just a few words on what we're gathered to talk about today. The trends in world and domestic politics that have made the question of autocracy and democracy so important right now, I think, are lost on no one in this room. We are all no doubt familiar with the many diagrams that show some version of the sort of height of democracy versus autocracy, with democracy in favor somewhere between 2010, 2011. I have one that I have used in various contexts by Our World and Data that shows a high point in 2011 with 101 democracies and 78 autocracies. And as of 2020, by their calculation, it had dropped to 99 democracies and 80 autocracies. One of the essential questions, obviously, is why? And then immediately following, how might a better understanding of what democracy and autocracy actually mean help us not only to understand what's happening, but ultimately, obviously, to try to think about how we might reverse this trend? I would submit to you these are questions that Tocqueville may help us answer. After all, the question of the relationship between autocracy and democracy, or what Tocqueville generally referred to as despotism or tyranny, he had his own sort of specific vocabulary, but it was central to his oeuvre. And I'd like to suggest quickly three ways that I think his understanding of this question may still be relevant for our conversations today. First, as important as these studies that argue for a slow process of democratic backsliding around the world are, for example, the figures that I just mentioned, the ways that these studies define democracy is quite different from the way Tocqueville and many of his contemporaries defined democracy. As we know, for Tocqueville, democracy was not simply a political system. It was certainly not solely defined by elections. As we said with Françoise yesterday, he spends more time talking about the impact of democracy on literature and poetry than he does on presidential elections in the United States. Nor was it defined solely by any obvious institutional markers. For Tocqueville, democracy was, of course, double. It was both a political and institutional system on the one hand, and a mode of social organization defined by his famous equality of condition on the other. Of course, by this, he did not mean a society in which everyone was economically equal. He meant an equality of condition grounded in a challenge to natural privilege and aristocracy. Second, Tocqueville highlighted that the process of the democratization of society was integral to modernity itself. In a number of instances, he suggests that it is not only a process that was taking place in the US or France, but he hypothesized that it would, in one way or the other, as he wrote in the original manuscript for Democracy in America, fill the world. However, and third, the democratization of society did not necessarily imply, in his view, that government too would be democratized. In fact, quite to the contrary, the great risk that he expressed in a number of ways throughout his oeuvre, and that he, to some extent, saw realized in Napoleon III, and saw as a consistent possibility within modern democratic societies, was that a new kind of despotism, or autocracy in our language, that would take advantage of individualism, atomization, and polarization, which tended to structure democratic society, would take hold. In other words, the great risk was that a democratic society would choose not to govern itself democratically, giving birth to a new and more dangerous kind of despotism and autocracy. I will say that it strikes me as obvious that in so many ways over recent decades, we have seen an extraordinary expansion of critiques of privilege and democratization of access to information and to a host of social practices and institutions that even as recently as the 20th century were reserved for a surprisingly few number of people. Critiques of gender, racial, sexual privilege have become hallmarks of our contemporary social landscape and clearly have emancipatory social potential. Just as knowledge production, participation in the distribution of information, both true and false, has been made accessible to unprecedented numbers of individuals, but with all the attendant expectations that come with such access. It would seem that there has been a further democratization of society in this deep critique of privilege and access. And yet, what also seems clear is that this horizontalization of social access and the critique of privilege that has fueled it has not generated necessarily more democratic government. Indeed, in some cases, it would seem quite the opposite, as if the new pressures towards the democratization of society have once again raised the essential question, how may modern democratic societies avoid autocracy and choose to govern themselves democratically? I think this is at least one part of the Tocquevillian background of what we're talking about. There will be many other themes treated over the next day and a half. I'm looking very forward to these exchanges, and thank you once again for your participation. So we will start with the first panel, which will be presided over by Catherine Audard, the editor of the co-editor of the Tocqueville Review with Michel Forcet, Justine Lacroix, who's with us from Bruxelles, and Laurent Pêche, qui sera avec nous en ligne pour nous dans le coin de l'écran. Merci beaucoup et bon colloque.
Welcome everybody. C'est un grand plaisir de vous accueillir au nom de la revue Tocqueville qui va publier les interventions donc, de ce colloque. J'accueille Justine Lacroix qui va introduire donc notre colloque. Justine est professeure au département de sciences politiques de l'Université libre de Bruxelles et vice-doyenne de la faculté de philosophie et de sciences sociales. Et elle est l'auteure de nombreux ouvrages, dont en particulier deux ouvrages qui anticipent sur toutes les les crises et les inquiétudes que nous pouvons avoir vis-à-vis de l'évolution actuelle des démocraties. Les droits de l'homme rendent-ils idiots? Un livre publié en 2019 avec Jean-Yves Pranchère, et surtout le procès des droits de l'homme, généalogie du scepticisme démocratique, publié en 2016. Et déjà, ces deux études sur la place des droits de l'homme, sur la révolution des droits de l'homme et la crise et la contestation qui les ont accompagnés, ces deux ouvrages vraiment anticipent sur le débat qui est le nôtre aujourd'hui, à savoir la contestation radicale, de plus en plus inquiétante, de l'état de droit et de la place que la protection des libertés fondamentales, des droits fondamentaux, doit avoir dans une société démocratique et pour encadrer un gouvernement, une forme de gouvernement démocratique. Donc, Justine va analyser la notion problématique et vraiment qui est devenue un espèce de signe de ralliement de démocratie illibérale, présentée par Viktor Orban, entre autres, qui est une forme de dérision à l'égard de nos démocraties libérales. Et elle va se demander, avec Tocqueville bien sûr, est-ce qu'on peut encore parler de gouvernement démocratique là où la liberté politique ne se trouve pas? Merci beaucoup, Justine. Donc, à peu près, nous avons une petite demi-heure peut-être avant l'intervention de Laurent, voilà. Et nous aurons peut-être 10 minutes de questions pour vous deux à la fin, voilà. Donc, oui, un petit peu.
Ok, je vais essayer de tenir
une petite demi-heure.
Donc merci Catherine, merci beaucoup de cette invitation. Moi, je suis vraiment très heureuse et très honorée de participer à ce colloque qui s'annonce passionnant. Alors, comme Catherine l'a annoncé, j'ai un peu modifié mon titre parce qu'au départ, j'avais à l'esprit une communication beaucoup plus large sur les doubles concepts qui circulent dans l'espace public, celui de démocratie libérale d'un côté, de libéralisme autoritaire. Dans la période moderne et contemporaine, on doit notamment à Bernard Manin d'avoir montré de façon magistrale comment s'est imposé le choix d'un gouvernement organisé selon des principes représentatifs qui étaient pourtant pensés à la fin du XVIIIe siècle comme radicalement différents des procédures démocratiques. Pour autant, je crois important de rappeler, contre une lecture trop rapide de Manin, qui était faite par certains auteurs, ça ne signifie pas que le modèle représentatif doit être pensé comme un procédé exclusivement aristocratique. Ça ne signifie pas qu'on puisse le réduire à la seule méfiance des élites révolutionnaires du XVIIIe siècle à l'égard du peuple, même si ces éléments étaient présents. Manin a bien précisé que le modèle représentatif est un gouvernement mixte, où la composante élitiste de l'élection est contrebalancée par l'exigence du consentement, marquée évidemment par la faculté de choisir ses représentants, par le caractère récurrent des campagnes électorales, qui oblige à anticiper le choix des électeurs et à rendre des comptes, et surtout par l'exigence que les décisions publiques soient soumises à l'épreuve de l'opinion publique et de la libre discussion. Et c'est justement pourquoi le respect des composantes démocratiques de la représentation suppose que soit garanti, outre le droit de vote, la liberté d'expression, d'association. Je rappelle que le droit d'association était qualifié par Tocqueville de presque aussi inaliénable de sa nature que la liberté individuelle. Seule, effectivement, la confrontation publique des idées, la possibilité de contester le pouvoir, permet de s'assurer que les représentants restent des représentants. Autrement dit, qu'ils ne se substituent pas aux représentés en oubliant qu'ils ne sont pas le peuple et en prétendant s'approprier la souveraineté du peuple, laquelle, c'est l'expression de Rosan Vallon, souveraineté du peuple en démocratie n'est pas une substance, mais une puissance que nul ne peut prétendre posséder ou incarner. Alors, ce qui me conduit au deuxième point, il me semble qu'il y a une méprise aussi, quand on parle de démocratie illibérale, sur le sens du peuple. Opposer la volonté du peuple aux droits de celles et ceux qui composent ce peuple revient à oublier qu'en démocratie, un peuple est une société. Il ne forme pas un bloc. Même Aristote, quand il disait que l'amitié doit unir les citoyens, il n'entendait pas sous ce mot l'homogénéité d'un caractère ou d'une identité. mais le sentiment de ceux qui se lient ou qui s'accordent pour régler leurs différends dans le respect de leur liberté. Alors bien sûr, une certaine identité nationale, sociale, peut être la condition d'accord des libertés, mais ce qui définit le peuple démocratique, ce n'est pas l'homogénéité, c'est l'égalité des droits. Ou alors, si on veut, ou si on pense possible d'identifier égalité démocratique et homogénéité, il faut faire sien le modèle de Carl Schmitt. Et on sait que Schmitt mobilisait les figures de Cromwell, de Robespierre, Napoléon, Mussolini, qui montrent que la démocratie peut se réaliser en dictature lorsqu'elle désigne un régime qui réalise l'identité des gouvernants ou des gouvernés. Cependant que les textes de Schmitt dans les années 1920 aient investi l'idée démocratique comme une sorte de totem pour raviver le sens du sacré en politique, ne devrait pas faire illusion. Schmitt et ses épigones contemporains ne font que prendre le masque de la démocratie. Ils travestissent la notion d'opinion publique qui est ramenée à l'unité d'une volonté alors qu'elle renvoie au partage d'un espace public. Il me semble d'ailleurs significatif que les auteurs attachés à défendre la pertinence du concept de démocratie libérale ou de démocratie autoritaire avancent des exemples historiques de régimes fondés sur cette volonté d'établir une forme d'identification entre gouvernants et gouvernés par le plébiscite, une philosophie de l'incarnation dans la figure du chef et le rejet de toute forme de pluralisme politique, qu'il s'agisse du bonapartisme, du césarisme de Louis-Napoléon, voire des débuts du fascisme. Alors, si on fait cela, il me semble qu'il faudrait préciser, comme le fait Rosan-Vallon dans son analyse du césarisme, que cette démocratie libérale n'est pas une juxtaposition de la démocratie et du despotisme. Ce n'est pas une sorte de démocratie sans la liberté. C'est plutôt, je cite, une pathologie interne de l'idée démocratique. Et c'est, en ce sens, je pense que c'est pour ça que je disais tout à l'heure l'extrait que je citais de Tocqueville ne me paraissait pas contradictoire avec l'avant-propos, parce que si vous prenez de nouveau Claude Lefort, quand il analyse le totalitarisme, lui aussi reconnaît que cette nouvelle forme de domination a été rendue possible par une certaine évolution des sociétés démocratiques, et notamment par une volonté d'annuler la division sociale au profit de la représentation d'un peuple un. Mais Lefort invitait à se souvenir que, je le cite, la formation de ce système implique la ruine de la démocratie. Elle ne donne pas une conclusion à l'aventure historique que celle-ci a ouverte, elle en renverse le sens. Autrement dit, c'est très clair, l'inversion d'une figure n'est pas la figure elle-même, l'inversion de la démocratie n'est plus la démocratie, une pathologie de la démocratie n'est plus ou n'est pas la démocratie. Alors, j'ai mon troisième point.
Oui, rapidement.
J'ai encore un peu de temps.
Voilà, 5 minutes.
Dernier inconvénient, à mon sens, de parler de démocratie libérale, c'est que ça pourrait faire, au fond, de renvoyer les déclarations des droits de l'homme du seul côté du libéralisme politique. Et pourtant, si l'expression « droits libéraux » s'est imposée dans nos espaces publics, il n'est pas sûr qu'elle fasse sens. D'abord, si on se situe par rapport à la grande opposition qui va structurer le XIXe siècle entre libéralisme et socialisme, on peut quand même voir que la proclamation des droits de l'homme en 1789, elle se situe quand même en deçà de cette grande opposition. Et on pourrait presque dire que le débat entre libéraux et socialistes, alors je sais qu'il y a libéralisme, socialisme libéral, mais non, le débat entre libéraux et socialistes est ouvert par la seconde phrase de l'article 1er de la Déclaration de 1789. Les distinctions sociales ne peuvent être fondées que sur l'utilité commune. À partir d'une telle formule, on peut aussi bien aller vers un libéralisme politique qui fera primer la liberté sur l'égalité qu'un socialisme démocratique qui fait de la liberté et de l'égalité deux composantes indissociables du même dispositif, comme l'exprime le vocable « égale liberté » forgé par Étienne Balibar. Je rappelle que la première apparition politique du socialisme, c'est le communisme de Babeuf, dont le journal s'intitulait « Le tribun du peuple » ou « Le défenseur des droits de l'homme ». On peut ajouter que la première moitié du XIXe siècle, en tout cas, une distance, pour ne pas dire parfois une méfiance vis-à-vis de la rhétorique des droits de l'homme, traverse l'œuvre de certains penseurs libéraux, pourtant acquis au principe de la Révolution, mais qui soit refusent la fiction des droits naturels, soit refusent la fiction des droits de l'homme, soit refusent la fiction des droits de l'homme, soit refusent la fiction des droits naturels, soit refusent la fiction des droits de l'homme, 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 soit refusent la fiction des droits de l'ho ou qui associe la revendication intransigeante des droits de l'homme à la terreur de 1793. C'est quelque chose qui va peser longtemps sur la mémoire des droits de l'homme. Même le vibrant plaidoyer en faveur de la liberté individuelle, publié en 1859 par John Stuart Mill, annonce d'emblée sa volonté d'écarter toute idée d'un droit abstrait, indépendante d'utilité. Plus près de nous, et de façon très différente évidemment que John Stuart Mill, on peut rappeler qu'un auteur tel que Hayek n'avait que réticence pour les déclarations de droit et le plus grand mépris pour celles de 1948 en particulier. Et donc, en réalité, il me semble que c'est bien plus autour de la nécessité de limiter le pouvoir sous toutes ses formes, et quelle que soit sa source, qu'autour d'une adhésion unanime et sans réserve aux déclarations des droits de l'homme que se rejoignent la très grande diversité des doctrines qualifiées de libérales. Et pour ceux des libéraux qui défendent la nécessité d'un catalogue de droits protégés, ces derniers peuvent être conçus avant tout comme des prérogatives que possèdent les individus et qui fixent des limites au pouvoir de l'État. Mais cette conception, que je baptiserais un peu vite de libérale, n'épuise pas la dynamique des droits de l'homme qui peuvent être aussi conçus dans une perspective plus sociale ou plus radicale, pas comme des attributs de l'individu, mais plutôt comme des principes constitutifs de l'espace social démocratique. Je renvoie ici aux lignes d'interprétation ouvertes par le fort et qui sont poursuivies par des auteurs tels que Rancière ou Balibar. Donc en fait, ce que je veux dire ici, c'est que les droits de l'homme, ils ne sont pas plus libéraux que socialistes ou conservateurs. Ils sont en quelque sorte désormais le bien commun de tous les démocrates et ils ne sont pas une sorte d'absolu. Ils ouvrent le champ des possibles. Ce qui conduit à une précision importante, c'est que refuser le vocable de démocratie illibérale ne revient pas du tout à soutenir que démocratie et libéralisme sont des termes synonymes. Il a existé des formes de libéralisme hostiles à la démocratie, mais ce qu'il faut voir, c'est que le mouvement démocratique du XIXe siècle, qui a tenté d'aller au-delà du libéralisme, par l'extension de la participation, l'élargissement des droits, la mise en place de droits sociaux, ce mouvement ne s'est pas défini comme illibéral et n'a pas remis en cause les acquis libéraux que constituaient les institutions de l'État de droit et les garanties de liberté individuelle. Donc je termine simplement, mon point était ici, c'est que, me semble-t-il, ce à quoi nous assistons, ce n'est pas tellement une dissociation entre, je dirais, la démocratie et la liberté, ou entre les composantes qu'on dirait libérales et les composantes démocratiques de nos régimes politiques, c'est plutôt un recul simultané des libertés et de la souveraineté populaire en plusieurs points de l'Union européenne, où les atteintes portées aux libertés d'association ou à l'indépendance des tribunaux ne se séparent pas des coups donnés aux conditions de formation de la volonté démocratique, aux conditions de formation de la souveraineté populaire, que ce soit en termes de capacité de critiquer, de délibérer et de s'associer. Je vais arrêter ici.
Merci beaucoup, Justine. Donc, nous allons enchaîner directement avec l'intervention du juriste, Laurent Pêche, qui va donc nous présenter ses travaux qui, depuis un certain temps, portent sur la façon dont l'Union européenne doit réagir face aux manquements vis-à-vis de l'état de droit. Donc la question vraiment de l'état de droit, du rule of law et de la protection des libertés individuelles est au cœur de ce processus qu'on pourrait qualifier de dégénérescence des démocraties, avec le titre du livre de Charles Taylor et de Craig Calhoun. Vraiment, ce processus de dégénérescence se voit très exactement dans l'histoire de l'Union européenne, l'histoire récente, l'histoire légale que vous connaissez si bien. Laurent Pêche est professeur de droit à University College, Dublin, et il est Dean of Law, Head of the Sutherland School of Law, mais c'est surtout un spécialiste de cette question des tensions internes à l'Union européenne, et en particulier de ce programme qu'il a dirigé, Reconciling Europe with its citizens through democracy and the rule of law. Non, on ne vous entend pas.
Il ne nous voit pas non plus.
Laurent, we cannot hear you. Just give us 1 second. We'll get the speaker going.
Well, while
Oui.
qui donc adopte des politiques parfois de la contradiction avec le respect des droits individuels au sens le plus classique.
Oui, oui. Alors bon, c'est un très vaste sujet que je maîtrise pas extrêmement bien, mais effectivement, c'est tout le débat sur est-ce qu'on peut reconnaître un certain nombre de droits collectifs qui, du coup, peuvent conduire à une limitation des libertés individuelles, comme le droit de choisir l'école de ses enfants. Enfin, je pense que c'est Charles Taylor qui avait beaucoup écrit là-dessus, où comment est-ce qu'une démocratie peut résoudre cela? À nouveau, ça renvoie, je dirais que si je dois vous donner une réponse du point de vue de la communication que je viens de faire, ça va renvoyer à différentes interprétations des libertés individuelles. C'est-à-dire que je serais tentée de dire c'est à la fois une question de délibération démocratique. Je dois m'arrêter là. Non, mais de toute façon, ma réponse est un petit peu confuse parce que je vais dire c'est une question de délibération démocratique. Pour autant que les libertés qui pourraient être limitées ne conduisent pas à une atteinte à la dignité de la personne. Je veux dire, c'est clair que entre imposer le choix d'une école en français à des parents ou ou autoriser une mutilation pour des raisons rituelles de façon permanente, on voit bien qu'il y a une problématique qui est extrêmement différente et qui renvoie dans un cas au respect de l'intégrité et de la dignité, et dans l'autre cas, un arbitrage entre des valeurs collectives et un attachement à des libertés individuelles. Je ne sais pas si ma réponse est très satisfaisante. Parce que
ça rejoint la question vraiment que j'avais à l'esprit en t'écoutant. Je me demande si toutes ces questions... C'est bon. C'est dommage parce que la conversation reprend, mais... Oui. Allons-y.
Laurent, can you try again? We'll see if we can hear you now.
Oui, bonjour, est-ce que ça marche cette fois-ci?
Ça y est, c'est bon, merci.
C'est bon? Donc, bonjour à tous, rebonjour. Et donc, pardonnez-moi pour les soucis techniques que j'ai causés en raison de ma présence en ligne et pas présentielle. Je ne peux pas malheureusement me déplacer à l'heure actuelle pour des raisons médicales, mais cela va mieux. Permettez-moi de vous rassurer. Donc, je vais évoquer avec vous, en fait, la question de la démocratie libérale d'un point de vue du droit européen. Et je vais le faire en anglais parce que j'ai écrit mon intervention en anglais, si ça ne vous dérange pas. Donc, merci beaucoup. So, a bit of context before I get to the issue of or legal issues, should I say. So, why are we even discussing this question from an EU law point of view, or what does it make sense to discuss the issue of illiberal democracy from an EU law point of view? I think it's important perhaps to just state some contextual information. In the EU, we now have at least one EU member state which is no longer recognized as a democracy by at least one EU institution. This country I'm talking about is obviously Hungary, which the European Parliament formally recognized as amounting to an autocratic regime. The European Parliament also described Hungary as the EU's first hybrid regime. The European Parliament also mentioned, Hungary and Poland as well have been recognized as being in the top 10 when it comes to autocratizing countries in the world, taking 2010 as a starting point. This situation is getting worse as we speak. In some latest reports regarding the state of democracy in the EU, Greece has been identified as one of the top autocratizing or backsliding countries in the world, taking 2020 as a point of reference. An additional number of countries have also been identified as experiencing backsliding patterns. I'm not going to mention them all, but Some of them have been downgraded from liberal democracies to electoral democracies. So as you can see, the situation from a democratic point of view is worse than ever. And in fact, the EU has recognized this to the extent that some exceptional procedures have been activated for the first time in respect of Poland in 2017 and in respect of Hungary in 2018. The special procedure I have in mind, I'm not going to explain how it works because this is not the purpose of my intervention this morning, but is known as Article 7 of the Treaty on European Union. It might be also worth mentioning that it's not simply the EU which is reacting, but quite often in a too little, too late basis. But the Council of Europe has also subjected Poland and Hungary to its own special monitoring procedure. So this is the context, obviously, the background to my presentation, which I'm going to divide in three main parts. I'm going to start with just providing you with a legal summary regarding references to democracy in the EU legal framework. And then I'm going to switch to references to illiberal democracies by EU actors, not only in political discourses, but also in EU legal and policy documents. And then I'm going to conclude with the question of whether illiberal democracy is actually compatible with EU law as it stands today. And I won't surprise you if I tell you that the answer is a clear no. But I get back to this point. So the first part of this presentation is about democracy in EU law prior to the rise of the illiberal democracy label. Here we can distinguish between references to democracy in EU primary and secondary law and references to democracy in the case law of the Court of Justice. The first aspect is quite well known, I think, at least among EU lawyers. The second aspect is less well known. I think people underestimate the increasing amount of case law from the Court of Justice regarding the principle of democracy. I'll get back to this, but first, EU primary and secondary law on democracy. The first point one can make in this respect is that in the early days of European integration, the EU treaties were silent on the democratic legitimacy of what was then called the European Economic Community. This is not surprising to the extent that the EU was first and foremost considered in the 1950s as no more than a typical international organizations. At least that was the dominant point of view among national governments. National governments also view European integration and the EEC as essentially amounting to no more than a creature of the member states' executives, which they intended to keep under their control. So initially, you could argue that the EU, which was then called the EEC, was very much a government, system of government for the member states and by the member states. In addition to this, the EEC did not comply with the traditional application of the principle of separation of powers. For instance, the EEC included a parliament, but the European Parliament, did not have any legislative power, and members of the European Parliament were not directly elected. In this particular framework, so it was not unsurprising to see that the concept of democracy was nowhere explicitly mentioned in the European treaties. This led scholars and even some political actors to start criticizing the EEC for suffering from a democratic deficit. I'm fast forwarding to the early 1990s. This criticism on the democratic deficit or alleged democratic deficit of the EEC was taken into account by the drafters of the successive amendments made to the European treaties. And the situation changed, at least as far as the references to democracy are concerned, in 1992 with the Maastricht Treaty. So the first explicit reference to democracy inserted into the European treaties. So there was a reference in 1992 inserted in the Treaty on the European Union to democracy, which was presented as a principle on which the EU is founded and a principle which is said to be common to all of the member states. This was also the time where the EU treaties included for the first time direct references to the concept of the rule of law and the concept of respect for human rights. In fact, democracy, rule of law, and human rights have since always been mentioned together in the main EU legal documents. There was, however, no comprehensive definition of how EU law understood democracy in those days. The situation changed in this respect with the Lisbon Treaty, which included for the first time a detailed set of legal provisions on the democratic principles underlying the EU legal framework. This is perhaps not also widely known, but since the Lisbon Treaty, the EU treaties contain some comprehensive developments regarding representative democracy, some aspects of direct democracy. You have also in the treaties much more powers allocated to the Parliament and national parliaments. And the EU Charter of Fundamental Rights was made legally binding at the same time. And the EU Charter of Fundamental Rights includes a Title V on citizens' rights. And this Title V guarantees a number of core democratic rights, such as the right to vote, the right to stand as a candidate in European elections and local elections, a right to good administration, a right of access to documents, a right to petition, and I can go on, but I'm going to stop there. Another important aspect, looking beyond the treaties, there's been an increasing number of EU secondary instruments, so essentially EU legislation mentioning democracy, mostly in the context of EU external relations law. So it's no longer true to argue that the concept of democracy is not defined comprehensively in EU law. The EU treaties, in fact, as I said, include multiple provisions on the core aspects of democracy. But if you start also adding to this the multiple legal instruments mentioning democracy, especially when it comes to financial instruments dedicated to promoting democracy abroad, then you end up with a very dense legal framework in EU law guaranteeing the main aspects or how democracy is normally understood. More recently, actually, we have seen also EU law guaranteeing participatory mechanisms. I can just give you a quick example in the context of EU recovery plans. So the EU is making a substantial amount of EU recovery money available to member states, but on the condition that they provide or they establish participatory mechanisms, including when it comes to law-making processes. So this is possibly quite new because instead of, prior to this, the EU was mostly interested in promoting democracy outside of the EU rather than within the EU. The same trend can be noted regarding the rule of law as well, where we see the EU increasingly defining core components of the rule of law. I can give you the example of the rule of law conditionality regulation. And interestingly, in this respect, the definition of the rule of law included in this regulation also refers to a democracy and the requirement of having democratic lawmaking processes. So as you can see, EU law, just if you look at the treaty and EU legislation already, we have actually quite a dense legal framework. The case law, perhaps unsurprisingly, has also grown quite significantly since 1986, when essentially for the very first time, the Court of Justice started protecting the prerogatives of the European Parliament in the name of democracy and the rule of law much more strongly. There was a very seminal judgment known as Lever. So essentially that's the starting point, I would say, of the case law of the court, the development of the case law of the Court of Justice regarding both democracy and the rule of law. Since then, there has been an increasing number of judgments, not only regarding the powers of the European Parliament, but also any other forms of governance governed by EU law, with the Court of Justice making sure that all actors are subject or remain subject to some extent to parliamentary control. There is also a huge amount of case law on the principle of transparency, with the Court of Justice connecting transparency with democracy to the extent that transparency provides means for EU citizens to hold their representatives accountable. The most recent case law, which I thought would be interesting to draw your attention to, is a case actually initiated by Hungary. So quite ironically, the leading case possibly regarding democracy in EU law is actually a case which was initiated by the country, one of the two countries subject to this exceptional monitoring mechanism I mentioned earlier. This judgment concerns the European Parliament's activation of Article 7 TEU. In support of its annulment application, Hungary alleged that the European Parliament violated the principle of direct democracy when he activated this procedure. This case is quite interesting to the extent that it shows that, contrary to what a lot of people assume, the principle of democracy in EU law is actually a legally binding principle which can have legal consequences in litigation. I think this aspect is quite often missed. And this judgment is actually a very good example of not only a party to the proceedings relying on the principle of democracy as a legal argument, but also the Court of Justice itself answering this legal argument on the basis of democracy, the principle of democracy. And in this specific case, the annulment application lodged by the Hungarian government was dismissed by the Court of Justice on the basis, inter alia, of the EU principle of democracy. So from the point of view of the Court of Justice, the Parliament did not violate democracy when he activated the special monitoring mechanism against Hungary. It's quite ironic in a way, I would note in passing, that the case law of the Court of Justice regarding democracy and the rule of law has grown significantly due in part Poland and Hungary lodging applications with the Court of Justice itself. But the bottom line is that EU law now provides legally binding definitions, very extensive definitions of democracy and the rule of law. It would be wrong from a legal point of view, at the very least, to argue that democracy and the rule of law, for instance, are just political principles devoid of any legal consequences and which cannot be the subject of legal analysis. This is just wrong from an EU law point of view, at least as interpreted by the Court of Justice. I would expect, my prediction is that you can expect the case law of the Court of Justice to grow significantly regarding the meaning of democracy in EU law in the next few years, if only because the situation is getting worse in both Hungary and Poland. Just this week, for instance, the ruling party in Poland adopted the so-called Lex Tusk, which essentially is a latest attempt to rig the next elections by essentially having a kangaroo commission rendering ineligible the leaders of the opposition on vacuous grounds. But let me move on to my second part, references to illiberal democracy by EU actors. The important point here is that essentially EU actors did not debate illiberal democracy before 2014. Why 2014? As you would know, this is essentially when Orbán made a very important speech, or at least a speech which was widely reported, in which he stated, among other things, that the democracy is not necessarily liberal. Just because something is not liberal, it still can be a democracy. So this is when essentially EU actors started mentioning illiberal democracy, but primarily in reaction to this speech by Orbán, By the way, Orban is now, has since rebranded illiberal democracy as Christian democracy, but less successfully, it would seem so. EU actors then essentially have reacted mostly in a political manner. But there are also some interesting conclusions you can draw from looking at legal and policy documents. But political references are much more numerous than references to illiberal democracy in EU official documents. The first legal document, or the first official document I could find mentioning illiberal democracy is from April 2000. So interestingly enough, the EU Commission published a communication on EU election assistance and observation in 2000. This is the first reference, as far as my research skills would allow me to find, to illiberal democracy, but the reference is very brief, vague in this document. No specific country is mentioned. And the EU Commission referred to illiberal democracy just before making a reference to the famous article by Farid Zakaria in Foreign Affairs, 1997, on the rise of illiberal democracy. So in this document, the Commission just mentions illiberal democracy, but without any attempt to define it. It's essentially just to warn that EU electoral assistance must take into account this new challenge. And then you cannot find any really EU documents mentioning illiberal democracy before 2015, which is when actually you have a significant number of political statements and interventions, mostly from MEPs, to denounce, to criticize illiberal democracy and the attempt by Orban to redefine democracy as traditionally understood in EU law. The best example of political reaction, however, is not from an MEP, but I would argue from the vice president at the time, Franz Timmermans, who was at the time the first vice president dedicated in charge of law. In a speech to the European Parliament in 2015, he stated there is no such thing as an illiberal democracy in the EU. If you look beyond the Commission and the Parliament, what is striking is that the Council of the EU has never used the concept of liberal democracy in official documentation, at least as far as I could find. General references can be found to autocratic regimes, autocratization, backsliding, but the concept itself or the notion rather of liberal democracy is nowhere, at least, to be found in official documents adopted by the Council of the EU. Generally speaking, when it comes to the situation within the EU, actually, the Council and the Commission tend to use very euphemistic language, and they have yet to recognize, in fact, they have yet to agree with the European Parliament's diagnosis that Hungary is no longer a democracy. In this respect, I would argue that 2022 was actually a breakthrough year when it comes to the concept or the notion of illiberal democracy, and an acknowledgement that the situation is getting out of control within the EU. Why is it a breakthrough year 2022? Because this is the first time that one EU institution formally recognized that one EU member state, as I previously mentioned, is no longer a democracy. I'm referring here to the European Parliament resolution of 15 September 2022, which concerns Article 7 and Hungary. For the Parliament, the European Parliament explicitly stated that Hungary is no longer a democracy, but must be considered the EU's first ever authoritarian member state. What is also interesting, possibly to note, is that the European Economic and Social Committee, a few weeks later, also agreed with the European Parliament. And what is perhaps surprising is that, in fact, after the European Economic and Social Committee based on my research, is clearly has been the most proactive vocal EU institution on the illiberal democracy front. In an opinion adopted in December 2022, this committee challenged quite straightforwardly the conceptual validity of the notion of illiberal democracy, and in fact went as far as to argue that we should stop using the concept so as not to give it any credence. It's a bit ironic in a way because they wrote an opinion about illiberal democracy while suggesting to the rest of us that we should stop engaging with this notion, but I can understand where they're coming from. Essentially, from their point of view, the notion doesn't make any sense, so perhaps we should refrain from using it. What is also interesting is prior to this, in 2019, this committee offered what I think is the only ever definition adopted by any EU institution of what illiberal democracy is. So if you don't mind, I'm going to share this definition with you briefly. According to this EU committee, illiberal democracies are political systems in which elections take place, but constitutional liberalism is not established. Democratically elected leaders restrict civic rights, civil liberties, and the protection of minorities. The system of checks and balances, an independent judiciary, and independent media are undermined in order to free the governing majorities from constitutional limitations and controls. This is, to the best of my knowledge, the only EU definition of illiberal democracy you can find in an official document adopted by an EU institution. Since my time is limited, let me move on to the last part of my presentation, which is about the compatibility of illiberal democracy with EU law. Here you can possibly adopt an institution by institution assessment or analysis. To begin with the position of the European Parliament, the position here is quite clear. Illiberal democracy is not compatible with EU law. According to the Parliament, you can draw the conclusion that there is no such thing as illiberal democracy, but illiberal democracy is just a way of legitimizing an autocratic form of governance. And in fact, Orban's the situation in Hungary is described as amounting to a systemic threat to the values of Article 2 TEU, with the Parliament also stressing that the Hungarian government bears responsibility for the restoration of compliance with EU law, implying therefore that what Hungarian authorities have done in Hungary since 2010 is fully in violation of EU law and the values enshrined in Article 2 TEU, which refers inter alia to the principle of democracy. In fact, another striking point in the resolution adopted by the Parliament is that the Parliament described the situation in Hungary as amounting to a breakdown in democracy. So this is the most striking, I think, aspect of the EP resolution. I've already mentioned the position of the European Economic Social Committee, which is possibly even stronger to the extent that they go as far as denying the very conceptual validity of liberal democracy, and also presents it as just a way of giving a veneer of legitimacy to what amounts to simply an authoritarian form of governance. In fact, in 2022, the committee was very clear. This is what they stated in their latest opinion on illiberal democracy. Illiberal democracy is not an alternative or even a diluted form of democracy. Illiberal democracy is no democracy. So this is from the opinion of December 2022 I previously mentioned. The Court of Justice has not been able to express a position on this basis because you could argue illiberal democracy is not a legal principle, and no one has raised any argument before the Court of Justice regarding illiberal democracy. However, what is interesting is that you have had many extrajudicial statements from the President of the Court of Justice in which he has made clear that authoritarian tendencies or drifts, to use the expressions the President of the Court of Justice used in a recent article published a few weeks ago. He stated that authoritarian tendencies we can see at member state level are not compatible with EU values. And this is what he also stated. EU law prohibits value regression, which implies that authoritarian tendencies can never form part of the EU's common constitutional space. They will never become part of the constitutional traditions common to the member states. So this is an extrajudicial intervention in the form of an academic article. The Commission and the Council have been more shy to the extent that for the time being, they would rather deny reality than confront the fact that Hungary is no longer a democracy. Why is that? Why are the Commission and the Council more reluctant to acknowledge the situation in the same way that the Parliament or the European Economic and Social Committee have done? Because if they formally acknowledge that Hungary is no longer a democracy, then it would have dramatic legal consequences on the adoption and enforcement of EU law. It would lead to essentially a legal breakdown in the day-to-day functioning of the EU, because technically, from a legal point of view, a member state which is no longer democratic must be legally prohibited from participating to any decision-making process. So this is why the Commission and the Council are now officially in a denial position. To conclude on my personal position, I would say liberal democracy is essentially just an attempt to legitimize what political scientists would rather describe as electoral autocracies. From my point of view, liberal democracy is just a way to disguise an autocratic power grab in practice. Illiberal democracy is incompatible with the EU principle of democracy as defined and understood and applied by the Court of Justice in its case law. There is no way you can argue that illiberal democracy, which relies on what Professor Schepelet has called autocratic legalism, so essentially where the rule of law is replaced by rule by law, is compatible with EU law as it stands today. My last point is that the EU has actually many extensive instruments and tools to legally and financially enforce compliance with core democratic standards against illiberal/authoritarian tendencies at EU member state level. The EU hasn't done so meaningfully in a proactive and decisive manner, but mostly because, or primarily because of political reasons rather than technical reasons. The tools and EU law is clear. Illiberal democracy has no room in the EU legal order. There is some recent developments which are perhaps worth mentioning very quickly. The EU is now in the process of adopting a new act to protect media freedom. There is also legislation to protect freedom of expression and freedom of association. The EU could do a bit more when it comes to free and fair elections. It has the power and it has the tools and it has the legal provisions to do so. But this is, for the time being, a too sensitive issue from a political point of view. But I would expect the Court of Justice, nonetheless, to develop its case law when it comes to free and fair elections. We have an increasing number of applicants actually challenging electoral results in their own member states on the basis of EU law. So as of today, perhaps the most important point is that the principle of democracy in EU law is a legally binding principle. It has been relied extensively by parties to the Court of Justice. The Court of Justice has protected many core principles of democracy. And you can expect the Court of Justice to be even more strict in its protection of democracy in the next few years. So thank you very much.
Merci beaucoup pour votre intervention et nous avons une petite dizaine de minutes de questions avant de poursuivre le colloque. Donc des questions pour Justine et pour Laurent, s'il vous plaît.
Alors, Justine, moi j'avais une petite question qui n'est pas, qui est un peu une question historique, mais qui m'intrigue, et c'est le fait que justement autour des débats, comme on parle de Bernard Manin, de la Déclaration des droits de l'homme, en 1789, le mot démocratie, aristocratie, les mots existent. On
oui, bien sûr.
On les emploie très régulièrement, on les emploie de manière relativement précise, d'ailleurs, plus précis que plus tard dans le siècle. Alors que le mot libéralisme, en tant que tel, n'existe pas ou...
Je crois que j'ai vu ça récemment, c'est 1810, la première apparition en France, en tout cas.
On a des variantes et donc, il me semble que ça va réellement dans le sens de ce que vous proposez, c'est-à-dire, bon, ce n'est pas qu'une question de nominalisme, mais c'est aussi une question de comment on conçoit la possibilité, les conditions de possibilité de la pratique démocratique. Et donc, je voulais juste poser un peu une question sur, peut-être, bon, c'est peut-être pas ce que vous avez parlé avec François, vous avez parlé un peu de la suite de 1000, s'il n'y a pas en quelque sorte une acquisition ou un entraînement de la Déclaration des droits de l'homme dans un discours libéral, alors que c'est réellement assez anachronique finalement par rapport à 1789. Mais s'il est possible de commencer à voir plus précisément quand, au XIXe siècle, on commence à associer droits de l'homme au libéralisme et démocratie à autre chose.
Ça, c'est une excellente question. Je crains de ne pas avoir la réponse. Enfin, ce dont je me souviens qu'on avait travaillé avec mon co-auteur sur l'éclipse du discours des droits de l'homme dans une partie du XIXe siècle, enfin éclipse relative, mais c'est vrai que en tout cas la première partie du XIXe siècle, il y a une certaine réticence. Il y a évidemment une défense très forte de la liberté de la presse, liberté de l'association et tout, mais la déclaration des droits de l'homme, c'est vraiment associé à Robespierre, hein, et c'est vraiment quelque chose qui va rester longtemps. Alors je suppose que c'est à partir aussi au moment où s'invente, alors là je pense aux travaux de quelqu'un qui devait faire un postdoc chez nous, qui va peut-être le faire, mais enfin il est pris ailleurs, c'est Arthur Gains, je ne sais pas si vous connaissez, qui travaille beaucoup sur ce qu'il appelle comment on a inventé, enfin comment on a construit une tradition libérale, et il montre comment au fond, la construction de cette tradition politique libérale, ça commence à peu près au milieu du 19e siècle, en France, hein, je parle toujours. Et donc la question que vous me posez, c'est de savoir à partir de quel moment on va associer, je dois avouer que là, je ne sais pas, je suppose que c'est à peu près au moment où la déclaration devient un symbole républicain, où on laisse de côté 1793, mais c'est une question très intéressante. Je me demande s'il y a des travaux là-dessus, parce que même Locke n'utilise pas l'expression droit de l'homme, et on le voit comme père de la déclaration, il y a quand même quelque chose dans la déclaration qui est extrêmement différent. Donc voilà, oui, ça c'est vraiment une question très intéressante de savoir comment dans la construction de cette, au fond, de la reconstruction de ce passé libéral, on a un moment associé, association qui n'est pas fausse, hein, mais qui me semble en tout cas problématique. Mais je n'ai pas de réponse précise, mais c'est vrai que c'est vrai.
Je pense qu'il faudrait regarder de beaucoup plus près les chartes, y compris les chartes de la monarchie en 1815 et après en 1830.
Oui.
Parce que ce sont des documents qui sont en permanence commentés, notamment à la Chambre des députés, dans tous les débats politiques. Et de ce point de vue, on ne peut pas considérer qu'il n'y aurait pas une vraie... je pense que le mot libéral n'est pas ce qu'ils emploient. Mais quand tu regardes les opposants...
1814, c'est sûr que non.
Mais les opposants de la Restauration, certes, ils sont toujours minoritaires à la Chambre, mais ils sont très nombreux. Tu prends Manuel, tu prends le général Foy, tu prends Benjamin Constant, etc. Et ils se réfèrent en permanence à la charte pour justement réclamer les principales garanties.
Oui. Et Constant écrit un texte contre Bentham, enfin pour défendre l'idée. Mais c'est pas la déclaration de 1789. Donc,
un orateur qui intervient sans arrêt en ce sens-là et qui n'est pas le seul. Et donc, il y a des textes théoriques dont il fait mention à la Chambre, parce qu'il y a un va-et-vient permanent entre ces textes et puis ces discours à la Chambre. Et l'enjeu, c'est véritablement ça. Donc, vous avez le temps encore pour une question.
Oui, pardon. C'est une question intéressante.
Il faudrait que nous disions
pour Laurent. Pour Laurent.
Parce que je pense que c'était vraiment très utile d'avoir le cadre légal, de ce qu'on entend par démocratie, parce que vous allez parler des valeurs et des principes, mais la traduction juridique est absolument essentielle, parce que ça objective, enfin, ça rend les choses beaucoup plus précises.
Laurent, I did have a question. Is there ever any attempt to determine exactly what being a democratic member state would mean? I mean, outside of the sort of case law that it would be speaking around it and would indicate, outside, I mean, once it is determined that elections are not the basis, has there been any sort of slightly more philosophical attempt to define what it would mean to be a democratic member state?
So thank you very much. I'm a lawyer, so I've been looking mostly at legal documents and to see to what extent there has been an attempt, legally speaking, to answer the conceptual challenge originating from this, attempt to redefine democracy. So the EU has been quite active when it comes to essentially identifying, defining more comprehensively the core aspects of democracy, rule of law, and so on and so forth. There has been no attempt, at least from a philosophical point of view, from the EU actors to reject the concept of liberal democracy, with the exception possibly of the European Economic and Social Committee, which has published many reports where they actually directly challenge the conceptual validity of liberal democracy. But that's about the only EU institutions which has done so, as far as I know.
So it's so there's sort of you kept speaking of this coupling of democracy, rule of law, that is precisely what Justine is discussing. But one essentially has to kind of hermeneutically extract what they mean by democracy. I mean, there must be a certain amount of slippage in the actual term, especially since they're trying to figure out who is and who isn't at some level.
So EU law, so legally speaking, you have many provisions, many texts defining some core aspects. So if you're asking for like a kind of a single document presenting all of the core aspects into in a simplified version, they haven't. So the EU has not produced such a document, but you can draw essentially the core aspects of democracy which are protected in EU law from the treaties and from the case law of the Court of Justice and from also EU legislation. The same can be done in respect of the rule of law as well. Is that the question you were asking me?
Yeah, I guess it was sort of what outside of the rule of law and some of these other sort of cognates that you're introducing into the term. What would you say since it's not elections? What would you say are the 2 or 3 pillars that seem to have emerged out of the case law as the cornerstones of European democracy?
So essentially, the cornerstones are to be found in the title of the Charter regarding citizens' rights. So this, I would say, in EU law are the core aspects of democracy: the right to vote, the right to stand, transparency, the right to a good administration. Perhaps people have not paid sufficiently attention to how EU law understands the right to a good administration, because actually then it refers to about 5 to 8 different rights, guaranteeing essentially access and challenge of admin decisions before independent courts. In addition to this, what is possibly the most interesting development in the past few years is that the court has connected, and EU institutions as well, have connected democracy more closely with independent judiciary, with media pluralism. There is also a lot of increasing case law and legal developments regarding freedom of association. Again, due to what happened in Hungary, so there is a leading case regarding freedom of association after they essentially attempted, successfully, in fact, to shrink the civic space by adopting what EU lawyers refer to as the Lex NGO. Academic freedom, actually, this is something I haven't mentioned as well, which is also one of the core freedoms normally targeted by autocrats, because of the attempt, following the successful, in part, attempt to expel the Central European University from Budapest. There was litigation, and then the Court of Justice was, for the first time, able to essentially define and guarantee academic freedom from an EU law point of view. So all of this can be essentially taken together as constituting the core aspects of democracy as understood from an EU law point of view. What would be helpful, however, is something which hasn't been done so far, has only been done in the context of the rule of law. There are some documents which essentially offer a rule of law checklist. So allowing you to assess to what extent a member state complies or does not comply with the rule of law. The same has not been done with respect to democracy. So in fact, that would be an interesting exercise to have an EU democracy checklist, which would allow to assess when a member state crosses a specific threshold, which means essentially that it's no longer a liberal democracy or electoral democracy. But to that extent, this work has already been done by a research institute known as the VDEM Institute, based in Sweden, whose findings actually have been used by the European Parliament, interestingly enough. It does not happen often that the Parliament would explicitly refer to academic research in a resolution. But this is what happened in September 2022, when the European Parliament decided that Hungary no longer constituted a democracy, and then referred to the work of this VDEM Institute and other some NGOs, such as Freedom House, for instance.
We have one last question from Art Goldhammer.
If the concept of independence of the judiciary is emerging as the distinguishing feature of a liberal democracy, if the United States were a member state of the European Union, would its judiciary be considered independent?
That's an interesting question. I would say it would be interesting to assess whether the US Supreme Court actually comply with the EU definition of what is an independent established by law court. But I'm not going to attempt to answer this question. I'm an EU lawyer after all, even though I did study in the US. But it is fair to say that the rule of law could be seen as being in clear and present danger at the level of some states in the US. I'm thinking, for instance, of Florida here, or North Carolina, or even Wisconsin, where free and fair elections may have been already violated in a systemic manner. But I'm going to stop there. I don't want to be too controversial beyond what is my field of expertise.
Thank you very much.